I'm Hillary Sklar. I'm an attorney in the Los Angeles Regional Office of Disability Rights, California. For those who are not familiar with my organization, we're a statewide nonprofit organization that provides advocacy services to Californians with disabilities, as well as training and technical assistance to advocates. We have a very full plate this morning on this topic of Medicare funding of AT, and my idea is this. Medicare is a very complex topic, and we have about 90 minutes this morning. So here's my thought. The webinar is designed twofold. One, as an overview to key topics to Medicare funding, and also it's designed for you to be able to review later on your own time. And then a second layer would be resources that are also available to you. I've highlighted some in the webinar during the discussion as well as at the end. And I look to those resources as a second layer of assistance, of advocacy, of explanation of law, and advocacy issues. And then the third layer would be specific client questions that may arise that would probably best be served by contacting Disability Rights California at the time you have the question. One of our 5 offices, Sacramento, Fresno, the Bay Area, LA, or San Diego, or there'll be some parts in the discussion where I might allude to HICAP for Medicare questions in particular. Otherwise, I'm not sure how we could cover it all. And as you know, our cases are organic, and so not everything can be covered. But my hope is that we will get key concepts reviewed this morning so that you walk away with a framework of key topics, help with issue spotting, and key terminology. The topics I will review this morning are an overview of the law and where to find it, Medicare eligibility, coverage of DME, durable medical equipment, some rules around payment, rules around a schematic for the appeal process, some notes and updates about healthcare reform, and also the competitive bidding demonstration project that some of you or many of you are familiar with. Before I begin, I have a few questions, and I think this would be a good time to use the hand-raising feature. In your practice, how frequently do Medicare, people with Medicare and Medi-Cal seeking funding for AT arise? Okay, my next question is, so we're still going. I couldn't tell very well. It looks like 7 to 8 people. So maybe, let's see, 8 people, we're still going? Okay, 8 people. How about in your practice, does Medigap ever come up? Clients that have Medigap coverage to supplement their Medicare. Okay, and my third question is, in your practice, how many people interact with the Medicare Advantage or Medicare HMO with the AT? Okay, thank you. That helps give me a bit of a sense of audience, and thank you very much. Okay, let's get started here. I put my contact information at the bottom. Again, we have 5 different regional offices, and our website will be at the end of the presentation if you need to contact someone in your region. Okay, so Disability Rights California operates through primarily federal grants, And one of the federal grants we receive is called the PAT grant, the Protection and Advocacy for Assistive Technology. For many years, in California, our name was Protection and Advocacy Incorporated, and then we changed our name to Disability Rights California. And this is funding that Congress created specifically for advocacy around AT issues in every state. And our funding, I listed the description, our funding requires us, asks us, encourages us to provide training like we're doing today to advocates, to training to consumers and clients and their family, their care providers, and also to provide assistance like our organization does in many respects to different levels of advocacy, from information and referral, counsel and advice, brief service, which could include our calling a third party on somebody's behalf to get information, evaluation and assessment of a potential case, evaluation and assessment of a person's rights. So, for example, someone has requested a piece of DME from Medicare and there's a denial. What are the person's rights? We would look at the denial letter that that person received. In some cases, we may provide direct legal representation, and I think that pretty much covers it. Our website also, in addition to the webinar today and the series that CFILC is providing, our website also has an AT manual. The links will be towards the end of the webinar. There's a specific chapter on Medicare, but it's very comprehensive, and Medicare is but one topic covered. So that's available as well to anyone who goes to our website. Okay, our first topic is laws and regulations and policies. And what I want to do here is just kind of situate you in where are we in the law. And Medicare rules are found under the Social Security Act, Title 18. And if you're looking for law, looking for information, the CMS, the Center for Medicare and Medicaid Services, should be a very helpful website. And I have the links here for medicare.gov. And you also want to always look for rules, and so the Medicare manuals are also available on the CMS website, so you have links for that. We'll talk more later, but if our big topic is Medicare, when we're talking specifically about coverage, we may have occasion to want to look at coverage determinations, both national and local. So I've provided you the link to where to find national coverage determinations, the manual for that. And on the slide that I just switched to, you also have the link for the local coverage determinations. The states are divided into regions. California is in Region D, and Noridian is the provider for our region. So again, a very broad overview, but my hope is to situate you in the landscape. We're under the Social Security Act, we're in Medicare, we're going to look at CMS. We want to know the idea that there are Medicare manuals and national and local coverage decisions, which might be relevant. Okay. Discussion about eligibility for Medicare. Schematically, there's sort of one date to think about, or one age, and that's 65. And there's Medicare for folks who are over 65, and then there's also Medicare available to some who are younger than 65. And the key to Medicare is it's not need-based, like Medi-Cal is. It's whether you have paid into the system, whether you have a work history or a work history through a relationship to parents or a spouse that you can draw from. So our first category is, is the person age 65 or older? Then if the answer is no, and the person is younger than age 65, we have some questions to ask. Is this person eligible? Do they receive Social Security disability insurance benefits? Or railroad retirement disability benefits? A person must receive, so first you have to be found eligible for SSDI if you're younger than 65, and then you must receive the SSDI for 24 months before Medicare benefits kick in. If someone is age 65 or older, then we're not concerned with this, and Medicare, so long as there's a work history, Medicare should automatically begin. Also, if someone is younger than age 65, we're going to look to whether that person has end-stage renal disease, and if that person, or if that person has ALS. These are two conditions, two situations where the 24-month waiting period for that SSDI to a receipt of SSDI will be waived. So as I mentioned, if someone is age 65 or older and qualify for Social Security broadly, we're not just looking at SSDI, Medicare will automatically begin. And if younger than 65, except for those two exceptions, there's a 24-month waiting period. And just as a review, there are different parts to Medicare. Part A provides your insurance in the hospital. Part B provides your medical insurance, so your coverage when you're not in the hospital. Part C is Medicare Advantage, or it's your managed care, your HMO, which some have, but not all. Part D is the prescription drug coverage. As I mentioned, Medicare is not need-based, so we're not going to look at your income or resource rules. It is determined by your work history. There has to be a work history, or again, someone's work history that you are permitted to draw from. The only time we really consider income or resources is for Part D, which is the prescription drug coverage. And under Part D, there is a low-income subsidy component of that, and that is when income and resources would be relevant. Does the person qualify for low-cost co-payments? So what we're going to do is, throughout the presentation, we've marked specific times to ask questions. So we'll open the floor now. I do want to present a caveat that a really good resource is HICAP. It's through the Department of Aging in California. It's free counsel and advice, information. I've gone to them many a time when I have specific questions. And so before I take questions, the focus of today's training is really on the AT piece. So if all right, I would like to limit the number of questions to Medicare eligibility and defer to after the webinar, or to HICAP as well, or someone's always welcome to call any of our 5 offices, but I'd like to really preserve as much time as possible for the AT piece. So I'll open up the floor now. Rosemary?
Okay, if you guys have any questions, you could use the chat window, and I'll go ahead and read out loud the question, or you can use your microphone headset if you have access to one. Just click on the microphone icon at the lower left corner. Thank you. Or you could use the raise hand features if you have any questions. Okay, Hillary, there were no questions, but Kelly Hart did make a comment. She stated that HICAP statewide number is 800-834-0222. Also, income makes a difference. Also, we got our Medicare savings programs. It helps with the Part B premium, etc.
Good. Thank you, Kelly. Okay, our next topic, now we're moving into the AT piece of things. What is covered and what is excluded? And the framework I thought might be helpful are what's excluded right off the top by law, statutory exclusions. And also Medicare, like Medi-Cal, has its own medical necessity test. And then the last two topics I've already mentioned a bit, national coverage decisions and local coverage determinations. So we'll talk about each of these. So generally, when Medicare funds durable medical equipment, they're expecting it to last for at least a certain period of time, and the time that they've set forth is 5 years. There may be things that happen to the equipment sooner than 5 years, or the equipment may last longer than 5 years. But generally, before someone asks for replacement, Medicare has this expectation off the bat. If something happens to the DME, such as it's lost or not repairable, and the loss or damage is not caused by an act of the recipient through misuse or neglect, then Medicare may consider replacing the DME. Another consideration, which really applies to customized equipment, are advanced determinations of coverage. And this process allows an advocate or beneficiary to ask Medicare first, before all the paperwork is done, and before the request is submitted, is this piece of DME something that Medicare would likely cover? And this is where the national coverage determinations and local coverage determinations and the evidence from doctors and physical therapists really play a key role. So this part would be very similar for those of you familiar with Medi-Cal, where the evidence is really critical, the quality of the evidence from the doctor, as well as doing the homework of looking at what does Medicare have a history of providing, or do they already say, no, we wouldn't cover this period. And this is a detailed subject, so I've added a link to Disability Rights California's AT manual, and Chapter 11 is our Medicare manual. And we have specific questions and specific practice materials for the determination coverage, the advanced request for advanced determination coverage. So I want to refer you to those for a more detailed discussion and materials that might be useful to you. But just conceptually, I wanted to flag this as a tool for advocacy, as well as, again, really emphasize the importance of the medical documentation. We'll talk next about the medical necessity test, but here the importance is always with medical documentation is to know the standard, know the necessity test, and then have a detailed discussion provided by the doctor that discusses each piece of equipment, each feature. So if we take a wheelchair, for example, that's a power wheelchair. Why is a power wheelchair medically necessary and not a manual wheelchair? Why was the manufacturer selected, why was Invicare selected over another manufacturer? Why is the power lift being requested, power tilt? Why must this person have a customized cushion? And why was this cushion selected over another cushion? Off the bat, we can also knock out Medicare coverage for some types of health care. So we know there's not dental care generally, or eye exams or eyeglasses, but for example, just as an aside, cataract surgery may be covered. So these are general rules, but it's really important as advocates that we always look to see if there is any coverage possible or any carve-outs or exceptions to these rules. But this is the starting point. So when considering Medicare as a funder, we have to look at their medical necessity test. Medi-Cal has their own, but for Medicare, their language is services are limited to those that are reasonable and necessary for the diagnosis or treatment of illness or injury, or to improve the functioning of a malformed body member. So when assisting someone with gathering medical documentation, or if you have occasion to review someone's medical documentation, you're going to use the standard that we just reviewed and look to the documentation to see if those topics are covered. Is there a discussion? I'm going to go back on the slide for a moment. Is there a discussion about why the equipment is reasonable and necessary to do one of the following, the diagnosis or the treatment, or to improve functioning? And we call that a nexus, creating the connection between the equipment and the law. I always like to think of it as the because. It's really helpful to have lots of becauses, as long as so long as the becauses are of quality. But I think of that as, in writing a sentence, give me the because, and that should tie the equipment to the law. Okay, a few comments about national coverage decisions. So if someone is asking you for advocacy in getting a piece of equipment, it's good to look at national coverage decisions to see if there's any discussion about that equipment. A few months ago, I received a call from someone who was trying to get a speech-generating device and wanted to know if there might be coverage for that. So we looked to the national coverage decisions. I provided the link to you. And so it's important to know from the start, is there already discussion about the piece of equipment? What is the realm that you and your client are in, to see, does this look like this might be straightforward, or will this require stepped up advocacy? The significance of the national coverage decisions are that they're binding to various players. That would include the regional carriers. We spoke about that California is in Region D, so Noridian is the carrier for us. And also, in the event of an appeal, if an appeal reaches the level of an administrative law hearing, the national coverage decision would also be binding there. So it's twofold. It's information while you're gathering the evidence for why this person needs this piece of equipment, and can also be helpful later should there be an appeal for argument purposes. Local coverage determinations are also required, and this is where we would look to Meridian. And what does Meridian have to say about a piece of equipment being asked? So to go back to my speech generating device example, we look to the national coverage determination, and then we look to see if Meridian had anything to say about speech generating devices, and especially the particular type that the person was seeking. So the slide that we're on now just are a few more considerations. So each region has their own manual of LCDs. They're not binding at the administrative law review level, but could be used for purposes of persuasion of argument. But they are binding at the level of, and I didn't define this, the QIC is the Qualified Independent Contractor. So again, the player's Meridian, who is writing these, and also possibly Maximus as well. And I've been using both the terms of AT, Assistive Technology, and DME. But in the world of Medicare, they don't use the term AT. They use the term durable medical equipment. So just a note, I mean, if we're amongst ourselves, we could use AT, but when speaking to Medicare, we have to speak their language, so we'd have to use the word durable medical equipment, or DME, and then be specific about what we're talking about. Are we talking about a wheelchair? Are we talking about a speech generating device? Are we talking about a prosthetic device or orthotic device? And durable medical equipment falls under coverage under Medicare Part B for when a person's not in a hospital and they're in the community. And there could also be some coverage if you're in the hospital as well. So for most of our purposes, I think we would look to the Part B component of Medicare. So it is provided. The purpose of flagging this is, yes, Medicare does provide DME, but we then have to look to each piece of DME and find out the rules to find out if that particular type of DME is excluded or included, and what the considerations are. So it's a broad overview. Any questions about coverage or exclusions, just the concepts of either.
You can use the hand feature if any of you have any questions, and then we'll just call on the participant name. Okay, Eddie, he has a question, and his question was, would Medicare cover for van conversations, and is this considered a MDE?
I'm not familiar with the product being asked about. Could you tell me more?
Eddie.
Oh, van conversions. I see the question. Van conversions. Okay. Thank you. Hold on. Let me go back to my chat. For the question about van conversions, and someone please correct me if I'm wrong on this, who would know better. I don't think van conversions would be considered DME. And someone please correct me. I think Mel, it looks like Mel, you have something to say. Yeah. So Mel says that as a reminder, and we'll get there in a moment, that Medicare provides only DME that helps you in your home. So anything that, so a van would be literally outside your home, and anything that you may use once you cross the threshold of your front door or any door of your home, Medicare won't pay attention to. Thanks, Mel. Okay, I'm going to go back to, there was another question. Let's see. Why, this is Maria's question, why is it so difficult for a consumer to obtain AT through Medicare HMO? I think one reason would be is because the HMO also adds another layer of rules. And I don't know specifically about Secure Horizons, but I think generally the more rules we add, the trickier it gets. And so it requires more research in navigation and advocacy. And also it may be an instance where the HMO just won't cover it, and they're permitted to do that. And so it's a consideration of, possibly switching to a different provider, different HMO. And I don't mean that to be flip, but sometimes the conversation just stops because the HMO is permitted to exclude coverage for something. Next question is about a stair lift. Off the top of my head, without researching it, I don't know the answer, and somebody may have had experience with stair lifts, but from the start, the first question of analysis is the one that Mel pointed us to, which is that it must be for in-the-home use. So as a starting point, it may be, yes, it would be for in-the-home use, but now we have to go to the Medicare manual and look under DME coverage, and then we would have to look for a national coverage decision, and then we would have to look for local coverage determination, and then if there's an HMO involved, we would then have to also look for coverage rules for that HMO. So I think for purposes of analysis for a piece of DME, I don't think you can ever just say generally yes or no, and that you really have to go through the steps. Is it for in-the-home use? And then the section we just completed around coverage and exclusions, to look at the different layers of rules every time a piece of equipment comes up. And Steve, it looks like you have a follow-up question. Who could look that up? Do you mean who could look up whether a stair lift would be covered? And if yes. Okay, so that could be an advocate, someone at the ILC could look that up. The consumer or the client could look that up if they're interested in doing so, and you can point them in the direction of where to find the rules. That could be occasion to call HICAP. That could be occasion to call us, though generally we are more apt to get involved when there's been a no, when something has gone wrong, and also before that, questions around medical documentation and preparing the medical documentation, the justification. Great. Looks like Kelly has added that HICAP has attorneys and paralegals who specialize in Medicare. That's correct, and that's why I mentioned them from the outset. So thank you, Kelly. It sounds cumbersome, but really, we have to look to the rules every time there's a piece of DME being considered, just to see what is already on the books and what the field is for trying to get that piece of equipment. And really, that's most important when it comes to customized equipment. Okay, are there any other questions for coverage and exclusions? And if not, I'll move on to our next topic. Okay. So I've already mentioned that AT is not the lingo for Medicare, that it's durable medical equipment. And DME is defined here as a piece of equipment that can withstand repeated use, is primarily and customarily used to serve a medical purpose. So again, I spoke of nexus earlier. We always want to have that connection to medical. There's a medical need, medical purpose for this item, and that might come up with a piece of equipment that may not ordinarily be considered for medical use, but there might be a reason why this person might need it medically. DME is also equipment that is generally not useful to someone in the absence of an illness or injury. And again, if you walk away with nothing else today, the point that Mel raised, it has to be for use in the home. And when we talk about people with Medi-Cal and Medicare, we'll talk about that as well. So what does home mean? Does it literally mean home? You know, what we consider you know, a residence, or can it be something broader? And for our community, residence and home can mean many things. And home, I put it in quotations just as a reminder to always check and think of where does the person reside. Are they in the home that they own or rent, or do they reside in the home of another, of a friend or of a relative, which would be permissible. And home could also be a residential care facility. There are times, for example, where a person may need a customized wheelchair and they reside in a nursing facility, and a nursing facility would not be considered home. There are exclusions for wheelchair coverage in nursing facilities. And just as a reminder about this word home, people often need features on their wheelchair that assist them in the community. And Medicare's rule is hard and fast. It must be for use in the home. If it's a feature that you would only use when you're in the community, the Medicare will say no. If it is a feature that has dual use for community and home, then it might start to look better. And in that situation, I would really emphasize the use of the home so that to try to minimize Medicare saying no because they see the word community over and over and over again. The emphasis, that nexus, that because must focus on use in the home. And just a note here as an example, in our manual, we have an example that discusses a portable oxygen system, and where Medicare had said no because that oxygen system, the portability, was for community use. I can hear the question, what if the person needs the portable in the home as well? Then I think you would look to the facts of that person. What is their need for the portability in their home? So the example given is an example. I would not use it as the hard and fast rule. I would do the analysis around coverage, and I would focus on, does the person need the portability in the home, or would a fixed, standing tank be sufficient? I'm seeing questions to the left, but I'm going to wait for questions until we finish this section. Okay. Orthotics generally, as a concept, so examples would be braces for leg, arm, back, and neck. And we're going to look to the definition of orthopedic devices for Medicare purposes, and that would be to support or align movable body parts or to prevent or correct deformities or to improve functioning. So earlier I talked about the medical necessity test. That is our starting point for analysis to whether or not this piece of equipment might be covered. And now we have another test, another standard for orthotics. Both would be looked to. So here we would want to ask the questions, ask our client, what is the purpose of this device? And we want to make sure that there is evidence from the doctor that it would do one of these three things: the support or alignment, the prevention or correction, or the improvement. And the Medicare Carrier's Manual further gives definition to what an orthotic would be, and that's the last bullet point on this slide. So the manual, in addition, says that an orthotic is a rigid or semi-rigid device used for the purposes of supporting a weak or deformed body member or restricting or eliminating motion in a diseased or injured part of the body. So again, more language to connect the evidence to get that nexus from the medical provider, from the doctor. Oops, this is what happens when I'm in charge of the arrow. Okay. I'm actually going to take questions here because I think payment rules come after. Oh no, I'm not taking questions yet. No, I am. Okay, sorry. Let's skip payment rules for now because that's our next topic. I'll take questions just generally around the definition of DME, definition of home, and orthotics. And then we'll talk next about payment rules.
Hillary, Sandra made a comment in the chat window. She stated, so for example, a power wheelchair may be covered, but the tie downs for transportation wouldn't.
Yeah, I think so. This question seems to be about the home versus community use, and I think that that's a good question. I would, if we use the home rule, then the tie downs for transportation, you've left the threshold of your home, and now we're outside, we're in the community. I generally would say no. And if anyone has any experience with tie downs, please, if you feel free to contribute. But I would say our starting point is going to be that home definition. Medicare is much, much, much narrower than Medi-Cal. And I think it's a real point of frustration. But it's the world that we live in and the rules that we have to operate within. I don't see any other questions, Rosemary. Are there any more on your end? Okay, let's move to payment rules. And I noticed that there was a question earlier about whether you'll receive a copy of the webinar. You will. And again, it's designed for use outside of this webinar, for you to go back to use as a reference and also to use the resource list and the links provided as well. So again, keeping with our theme of general considerations, Medicare pays only 80% of services. That's true not just for DME, but it is true for DME, so let's talk about what this looks like. So if Medicare only pays 80%, how is the other 20% covered? And many of you may have experience with this already. And this is where we'll talk about HMOs, Medi-Cal, and Medigap. So really there are 4 routes to covering the 20%. The Medicare beneficiary could pay for the 20% on their own, out of pocket. The Medicare beneficiary may want to purchase a supplemental coverage in the form of a Medigap plan. A person may be recipient of both Medicare and Medi-Cal. In the case of having that dual eligibility, of being a Medi-Medi, Medi-Cal would pick up the additional 20%. And then in the case of a person who does not have Medi-Cal and does not want to buy a supplemental coverage in the form of Medigap, the Medicare Advantage or HMO may pick up that additional 20%. Let's first talk just for a moment about Medigap. One person indicated that this is an issue, so I'll be brief and defer to HICAP for their research information and their publications on their website. So basically the concept here is the person is buying a supplement plan. It's a private plan with an insurance company. There are many, many, many plans out there and many different levels of coverage. And really I would defer to counseling from HICAP because of all the considerations that go into selecting a plan and the rules about when you can and cannot switch plans and levels of coverage. Conversely, Medigap plan may be a consideration for someone who can afford supplemental coverage and also wants the freedom of choice. I think one could akin Medigap plan to a PPO, where unlike managed care in a PPO or Medigap, you pick your doctors. You go when you want to go. And depending on the plan, you may pay nothing out of pocket but the premium for the plan, or you may pay a copayment, and there would also be drug coverage involved as well. So I really, really want to direct you to HICAP if someone is interested in Medigap because of all the considerations and all the different types of plans. But this is just one option for coverage for the 20%. Medi-Medi. So if a person has Medicare and Medi-Cal, we want to take note and also know that in addition to satisfying the Medicare rules, we really have to look to the Medi-Cal rules as well. Medi-Cal will be our primary contact here for the request. And under a case called Charpentier v. Belcher, Medi-Cal is responsible for paying the amount that's above the Medicare's rate. So that would include the 20% not covered by Medicare. So what I've included here is the process. So we would treat a Medi-Medi as if it is a request to Medi-Cal, because that's what it is. Medi-Cal will process the paperwork and then send it on to Medicare for coverage of the 80%. So just like a DME for Medi-Cal, a TAR, a treatment authorization request, must be submitted to Medi-Cal, and that includes discussion of medical necessity, because Medi-Cal won't pay if it's not medically necessary under the Medi-Cal rules as well. So just a reminder that if Medi-Cal approves the TAR, the person would then get the equipment, and Medi-Cal would then forward the bill, the remainder 80%, to Medicare for payment. Oops, did it again. I apologize. And I really want to emphasize the need for advocacy and preparation when someone is both Medicare and Medi-Cal beneficiaries. And so I want to refer you for a much more detailed discussion to Disability Rights California's AT Manual. Chapter 10 talks about Medi-Cal and has a discussion about dual eligibles, and also to Chapter 11 for Medicare. And just as we discussed under earlier with Medicare and the medical necessity test, medical justification is key, and this is really significant when we're talking about custom equipment. I used wheelchair as an example, but anytime something needs to be customized, there must be strong medical justification. There must be that nexus explaining why. Last year, Disability Rights California provided a webinar about Medi-Cal funding and medical justification, and if that's still available, I would refer you to that as well. Any questions about Medigap or folks who are Medi-Medi?
Hillary, Kelly Hurt made a comment in the chat window. Some people also have retiree union health benefits that supplement Medicare. Also, some coverage may be available through the VA.
Okay. Great. Thank you, Kelly. So I think for purposes of this section around payment rules, we just have to keep in mind that we've got that 80% that would be covered if the piece of equipment is approved, and then what are the options for coverage under that the missing 20%. And so we just look to what does the person have available to them, or what type of coverage are they interested in supplementing with. And then as Kelly pointed out, there may be these other categories of coverage as well to supplement. So thank you very much. Oh, no, Kelly, don't apologize. I appreciate all the assistance that's being provided. Okay. A few words about Medicare Appeals. I think Medicare Appeals could be its own training. So what we've provided for you for this training is, again, a schematic. And really just wanted to flag that there are different steps, different levels where you can go to find those specific rules. And so let's jump in. So the question here is, if someone has been denied coverage or denied replacement DME, the question we want to ask is does the person have what we call traditional or original Medicare? Or are they enrolled in Part C, the Medicare Managed Care Medicare Advantage program, and that's providing the coverage for the 20%. So by traditional original, I mean someone is Medi-Medi, or someone has a Medigap coverage. I'm not familiar off the bat with VA and union coverage, so I don't know if there's another process there, and I apologize for that part. But let's just talk schematically if the person's in traditional Medicare or Medicare Managed Care. So as an overview, if the person is in traditional Medicare, there are 5 potential steps. The first is to request redetermination. Before this gets really big, let's just see if Medicare would reconsider, would look again at the evidence, or perhaps there is some supplemental evidence that could be added to further elaborate on what was originally submitted. After the redetermination level, it would move to, if that doesn't resolve the matter, would move to reconsideration by the qualified independent contractor for the region. So you're not dealing with Medicare directly now, you're dealing with the contractor, the independent contractor for the region. If that level doesn't resolve the issue, now we're moving to a fair hearing with an administrative law judge. If that doesn't resolve the matter, the next level is the Medicare Appeals Council. And if that doesn't resolve the matter, now we're looking at federal court. I'm skipping ahead for a second on the slides because I cannot emphasize enough how important it is to pay attention to dates and timelines. And because we thought that the presentation might go long, what we did instead of giving you all the details, I'm giving you the links to California Health Advocates, that's HICAP, their links on appeals, which talks about every step and what's included in every step, what must be considered at each of those steps that we just looked at, each of those 5, and the timelines. And Disability Rights California, our manual, also has additional discussion. And I think between the two, you would have a really full discussion. There'd be some overlap, but also each publication gives its own information that's not covered in the other. But I think you'd be well covered with both. But if there's nothing else that you take away from the section on appeal, is I don't know that you'd have to memorize the different steps, but it's please, please, please pay attention to the timelines, because every step has its own timeline and its own requirements. And we'll also have information about who the players are, who is being addressed in the communications. If a person has Medicare Advantage, then there are also 5 steps, and that looks very similar as well, but the players are different in part. So step 1, again, is reconsideration, but it's asking for reconsideration by the plan. So, for example, Secure Horizons or Kaiser. This is a communication to that entity, not to Medicare. The second step looks similar to traditional Medicare. But here the terminology is independent review entity. Step 3, 4, and 5 are the same as under traditional original Medicare. Administrative review by an administrative law judge. If that doesn't resolve the matter, then it's going to the Appeals Council, the MAC. And if that doesn't resolve the matter, then we're talking about federal court. From an advocacy standpoint, I don't think it would ever hurt to consult an advocate or attorney at any point, at any of these steps in either appeals process. I would especially advise it once you're talking about an administrative hearing, or the Medicare Appeals Council, or federal court. So again, the links for the detailed discussion and the timelines. And if you were to go to one resource first, I would start with HICAP, with the California Health Advocate materials, because they just lay it out, the overview and the timelines and the players. And for the real detailed discussion, I would look to Disability Rights California's AT manual. So you have your links for traditional Medicare, and then both HICAP and our publication talk specifically about managed care as well. So I know this is really a summary, but are there any questions generally about appeals? I see that there's a comment from Sandra that says, but then it will come back in a couple months denied. I'm not sure what that is in reference to or if that was directed to me. I'm just looking at the comments. I see Kelly added a comment. HICAP always says appeal, appeal, appeal. I don't see any additional clarification to Sandra's comment, so I'm not sure if there is one. From an advocate standpoint, when somebody calls our office and says that they were denied coverage for DME, my first question is, I want to see the paperwork. And so I offer that to you as advocates. You have to see the paperwork. And that doesn't just mean the denial. It means what was submitted in request of the piece of equipment. So for Medi-Medis, what was submitted to Medi-Cal. For folks that do not have Medi-Cal as well, what was submitted to Medicare. It's all in the writing. So you want the denial. And if it was just denied over the phone, that's not good enough. You need it in writing to explain that they want to say a date, to have the reason why it was denied, and the written transmittal also gives appeal rights. And you want to see, what did the person submit? What did the doctor have to say? And oftentimes, in my opinion, I find the medical evidence lacking, that it could be stronger, or it doesn't address the medical necessity test, or does not stay within the discussion, doesn't point to the home use, or doesn't address the definition of that piece of durable medical equipment. So if someone comes to you, I would ask them to bring, or to fax to you, all the paperwork that went into the review by Medicare or one of their contractors. Okay, Sandra, I see your additional comment. Some issues have arisen where people will be told by the vendor that they will be approved for a wheelchair, but then later will be told they've been denied. They will, let's see. They will get the item only to have to return it because a couple months later because Medicare denies it. So how can a vendor give a consumer DME without an approval? My first concern is with a vendor saying that they will be approved. My question would be, what evidence, what information is the vendor basing that assurance of approval on? Is it because the vendor in their experience knows that this particular piece of DME will be approved, or do they have an approval from Medicare in hand? My next concern is about returning it. I think that raises possibly some issues about reliance, but if the vendor is providing equipment that they don't have an assurance will get paid, that sounds to me like a risk the vendor is taking, that they won't get paid. I think from a self-advocacy standpoint, my question again is, what is the vendor basing that assurance on? And, show me the writing. Please provide me with a copy of the approval by Medicare. Please provide me with the TAR approval from Medi-Cal. Looks like Kelly has a comment. Sounds like a sales pressure tactic. If they like it, they may figure out a way to pay themselves. Alan says vendors advertise guarantee approval for scooters and chairs. Again, my question is, how do they know it's guaranteed? Kim, you have a question.
Hi, I just wanted to let people know a situation that happened in my family just recently. My mom needed a wheelchair, and they she was doing it all on her own, and went there and they said, oh, this wheelchair is always covered by Medicare, it shouldn't be a problem. And so my mom took the chair, and then afterward they said, oh, it wasn't approved, and so you're going to have to pay for it, and really pressured her. And she actually paid for it because she didn't want to get me involved, and just told me afterward because she felt like she had been duped. And it was actually, no, it was a wheelchair rental, and so she paid for the rental of the wheelchair that they had told her was covered by Medicare. So it just seems a little bit odd.
Mel says he would take the vendor to small claims court for reimbursement, I'm guessing. Yeah, I think before it even gets there, the question to the vendor would be, show me the proof that you have an approval in hand, to try to avoid some of these things happening. Sandra says, sounds like more of a vendor issue, so we'll have to, I can't keep up with this. Okay, I think you guys can see the comments. I can't quite keep up as they're coming through quickly. Yeah, I agree. Yeah, these are vendor issues and not Medicare issues, and I actually think that's a good reminder when considering who the players are, that Medicare and in the case of Medis, those entities may not be the recourse because they may not be the bad actor. The vendor may be the bad actor, and so it's what are your rights when something goes wrong on the vendor piece of things. Okay, so some good suggestions here about small claims court, about dealing with the vendor directly. Also a note here that HICAP has a abuse and fraud conference coming up as well. Question is, do you come to Disability Rights California when it's a vendor issue? I would say really no. We have information about lemon law, but that becomes more of a consumer issue, and we can provide basic information and have in our AT manual information about your lemon law or problems with vendors, but it's not our specialty. It is a consumer issue, consumer law issue. So while anyone is welcome to call us, there may be more to the facts that going on, and maybe it wouldn't hurt to call us and review it with us, but the reality is we may very well refer out on a consumer law issue. And I have a case like that right now where it was not a funding question. It solely has to do with the vendor, and it was something that I unfortunately had to deny representation for and defer to consumer law specialists. Okay. Just a note about guaranteed coverage. Off the bat, we know that Medicare, like I mentioned earlier, Medicare will not pay for wheelchairs for nursing facility residents. So that one we do know is close to a guarantee for exclusion as we can get. There's no coverage, and so you have to look to other sources there. For nursing facility residents, and that's this not for in-the-home use. They've excluded nursing facilities from that definition. Okay, looks like it's okay to move forward. So just a few comments about healthcare reform and also the competitive bidding pilot project. So with healthcare reform, came a few more rules, and that is that now before DME can be prescribed, the Medicare beneficiary must meet face-to-face with the doctor, and that doctor must be enrolled with Medicare as a provider. There's also this language of other eligible professionals as well, which could be I would look to the rule, but may include like a physical therapist. But I know that they're going to want that doctor contact. I have not interacted with anyone who's come up against these rules yet, so I can't provide any examples. If you have, please feel free to chime in. So guidance on eligible professional and enrolled physician are provided. I didn't give you the starting point. I'll send this to Kim. The reference to the section for each of these regulations. I apologize. It's in the Affordable Care Act, but I'll provide the information that goes before the section symbol. My apologies. There's a helpful discussion about DME at the CMS website, and I would refer to that link for further discussion. And again, I apologize. This is not something I've interacted with yet here, so I don't have much more than where to send you for the discussion of how this might play out. Question from Julie is, would an OT be covered? I would look to the regulation for that, and I'll send you the preceding discussion. My apologies on that. I'm very sorry. Generally, I would think maybe OT could be included, but again, I don't want to say with any certainty. Okay, any other questions? This is just very brief, but it's really more where to find information. Okay, the last topic is about competitive bidding. And this is a pilot that's not happening statewide yet, but is happening in a few counties. And really what competitive bidding does is it narrows who a person can go to for DME and sets some caps for coverage. So the counties involved in the pilot are San Bernardino, Ontario, and Riverside. And additional lingo acronyms would be CBA, which these counties are considered a competitive bidding area. This affects a person who is residing in one of these counties or areas, or perhaps is visiting. Maybe something happens while they're visiting family or passing through or on vacation, even though they don't normally reside in one of these areas. So the purpose is to limit fraud and abuse, and it's also intended as a cost savings. This affects beneficiaries who are only in that original Medicare program. So we're not looking at Part C. We're not talking about managed care at all, or the Medicare Advantage program. We're just looking at traditional and original beneficiaries. So some examples, and this is not a complete list, but an example of the type of DME that would be affected would be your standard wheelchairs and also anything that's complex or custom as well. And the key here is that the beneficiary cannot just go to the vendor of their choice. They have to go to an approved contract supplier. And that's for initial coverage of that item. If the matter involves a repair, the field opens up again to now choice between that contract supplier or to the wider field of a Medicare provider. If it's complete replacement, again, it has to be funneled to only a contract supplier. So if it's something new or being replaced, the beneficiary has to now deal only with the contract supplier. And if it's just a repair, then the field is open and there's more choice. And I've given you the link to the DEMOS link to how a beneficiary can identify who is a contract supplier in their area. And also I would refer to the 800 number for Medicare for questions. We've not gotten any calls about competitive bidding, and I don't know if anyone is from any, going through the list, I don't know, just looking at your names, if anyone is affected by the competitive bidding projects and has anything to add. It's what the reality is right now, but it is a pilot, so it doesn't mean that it's fast and certain to continue on forever, but it is the reality for now. See, there's a question from Nancy. It says, we'll get a copy of all this. Will that come in the mail or should they print? And Kim, can I defer to you for that?
Hello. We can send out the PowerPoint, push it out at the end of the presentation, and then I can send it out. I think that's the easiest way to do it. So we'll just send it out. You can download it immediately. I'll get it ready. And
this is Hillary. I'll send the full citation for healthcare reform, and again, my apology for that oversight. So really the purpose of talking about healthcare reform and competitive bidding are that these are just some things to be aware of, to flag, to keep in mind. Other than the changes around the face-to-face contact, we don't know of any other major changes to DME coverage under the healthcare reform, though that is a big change, the face-to-face and the definitions of physician and other healthcare provider. And then the other one was the competitive bidding, just to flag it, that it's not statewide at this point. A question from Kelly, healthcare reform provides more preventative care under Medicare. Does that have any impact on DME? Again, what I provided is what we knew of, and so I don't know the answer to that. It would involve closer inspection of the healthcare of the Affordable Care Act. And if I'm going to scroll back a second in the webinar, I would look to the Open Door Forum as a starting point to answer your question. Okay, and Kelly said that you guess it answers your questions. Maybe the face-to-face takes care of wellness preventative care. Possibly. But again, I really would, because this is so new and it's just starting to play out, I would look to the CMS publications on this topic. We don't have anything new on it other than what I'm providing you. Okay. Any questions, any other questions about healthcare reform or competitive bidding? So the last thing you have in your webinar are additional links for resources that I hope will be of help. So you have the links to Disability Rights California's AT manual for Chapter 11 on Medicare and Chapter 10 on Medi-Cal. And for Medicare, we had it also PDF and on the HTML. So I gave you both links to that. And I also wanted to give you a few other ones. We've already mentioned HICAP many times, and you have in the webinar links to specific documents on specific topics. But if you aren't familiar with HICAP already, the link is the third bullet on the page. And then additionally, the CMS website has a specific website dedicated to durable medical equipment. and so that's the second link for CMS.gov. And lastly, I wanted to highlight a publication from an organization called Neighborhood Legal Services. And I actually see, I think, what looks to be a typo. I see your comment, Kelly. I'll read it in a second, the link. For preparing letters of Medicaid medical justification letters. And I would say that this is a good primer, just period, for medical justification letters, whether it's Medicaid or Medicare, the difference being the medical necessity test. Neighborhood Legal Services is an organization in New York that provides backup on AT issues. There's also Neighborhood Legal Services of San Fernando Valley here in Los Angeles. That's a different organization. The typo in the link is it should be www.nls.org, and it looks like I had a comma by error. Okay, let me go back to the question about, can I read the open door form link? Okay, let me see. Okay, I see that the question is about underscores. They aren't in this link. Looks like if there are, my guess would be that there between the 17 would be an underscore ODF underscore HHS. I would try it with the underscores there. And I will check that when the webinar is concluded and send the note to Kim to send out to confirm. Yeah, so Kelly, I hope that answers your question about is there anything between the I think the I don't know. I'm going to have to double check it because it looks like the automatic kind of link format did away with any potential underscore. So I will check this link and confirm with Kim to send out to all of you. Okay, I think our time is up. This is really a broad overview, but again, my intent here was just to give a framework of the key topics, the key considerations when we talk about Medicare funding, and as the first layer, and the second layer being these links to resources to us, Disability Rights California, to HICAP, to Neighborhood Legal Services, to CMS, and especially their DME Center website. And then the third level would be more detailed, complex questions or case questions or client questions to direct them to Disability Rights California or to HICAP as well. Any final questions? So I will confirm the link, and I will confirm the citation for the Healthcare Reform Act.